The mother of the Oxford High School shooter has asked the judge in her upcoming trial to block 3 witnesses from testifying. She is charged with involuntary manslaughter. Her case and her husband's mark the first time a parent has been criminally charged for a school shooting that their child carried out.
Now, the 3 witnesses that she is asking to block include a teacher who locked eyes with the shooter, an assistant principal who tried to save a dying student, and another student who was in the bathroom while the shooter started to kill a classmate.
We're joined today by attorney Sanford Shulman to unpack this motion. Thanks for joining us today.
Thanks for having me.
So the 3 pieces of testimony that Terrence just mentioned, we all sat through and listened to that over the last summer during the Miller hearing. They are excruciatingly painful. Does her team have a point in that it's not relevant to her case?
Yes, what they're trying to do is ask the judge to be very focused, to keep the jury not distracted by the emotion. It's their tactic, and makes sense. They're trying to keep the jury focused on the law and applying it to the facts in this case. The government, the prosecutor, is trying to introduce their case, which is very emotional. What comes out of this is the judge wants to make sure it's a fair trial, and to ensure it's a fair trial, we keep irrelevant things out. So that was the first part of the motions. This now is, even if it is relevant, is it so prejudicial that it doesn't have any probative value, that the prejudicial factors outweigh the probative value. And then you have the idea that the jury will have to decide a case on emotion. And we know as humans that when we make decisions on emotions, whether it's anger or love or even jealousy, or whatever it is, if it's emotional, sometimes it's not a clear decision, it's a clouded decision. And that's what the judge, and that's what our process is trying to avoid, a clouded decision based on emotion. And we need to focus on the facts and applying it to the law, applying it to the facts.
Now, here at CBS Detroit, we had gavel-to-gavel coverage of the Miller hearing, so we heard a lot of that evidence extensively, a lot of it pointing to those parents. Right. How are they going to be able to argue whether or not there is separation there? Because we do know that some of their actions, from what we saw, did lead to some of what we saw play out.
Sure.
Unfortunately, with this
so that's the prosecutor wants to show that the parents were grossly negligent. It's not a civil case. If you think about divorce cases, those are emotional. Civil cases are emotional. In a criminal, it's extremely emotional. And so we have this testimony of these witnesses, and the defense is saying, let's keep those out, or at least really limit it, and focus on whether the parents should be held responsible for the actions of their child. And it really will open up a whole can of worms. Really, the whole country and a lot of legal professionals are watching this carefully, because you can imagine every juvenile case, are the parents responsible? Are we all responsible for everything our child does or children do? That's kind of what this case is bringing out.
What's the reasonability factor? What is each side trying to convince the jury was reasonable or unreasonable here?
Right. So that's, both parties are going to be, the facts are not necessarily in much dispute. I mean, what happened on that terrible day is not in dispute, and the parents, what they did is really not in dispute. The question is, does it rise to a level that it's criminal? How much do the parents know? How much was their actions grossly negligent? You know, and it's a lot of it's Monday morning quarterbacking, but when you look at this case and you look at what happened, the emotions could really lead to, well, you should have done this, you could have done this. But in the reality is, did the parents commit a crime? And although, again, it's just as emotional, those Miller hearings, was it a crime what they did? You know, having a firearm, having your child, you learn how to use one, take them to target practice, and then they commit a heinous crime. Now you're on the hook.
Based on the evidence that we've seen so far, do you see them taking any kind of accountability as far as the parents are concerned and their team?
Well, accountability would be a plea. There's been no offers, so that's not happening. And so they feel that they didn't have any foreseeability of what was going to happen. I mean, it's clear that this individual had mental issues, and it means reasonable that he probably should have been monitored more. But the question is, did his actions relate directly to what the parents did? You know, when people are charged with crimes, either you did something or you aided and abetted. I helped you commit a crime. The parents did not go to that school. They didn't help him in knowing that he was going to commit this crime. What happens is, the prosecutor's theory is that they were so grossly negligent. It's a really novel application. It's being watched carefully, and it really calls into question whether parents should take that extra step to make sure that things like this don't happen in the future, and that's kind of what the prosecutor's hoping for.
Do you think any of the extenuating circumstances in this case will impact it, whether we're talking about the parents' actions after the shooting that everyone witnessed through news coverage, or the unprecedented nature of these charges? Will any of that help or hurt their case?
Yeah, it's absolutely going to hurt the defense. Because most prosecutors across the country have not charged parents with these kind of crimes. They just don't come into play like this. This is a very novel and a unique challenge to the law. Charging someone with manslaughter, involuntary manslaughter as parents is really unusual. So bringing in all this evidence, which is relevant, the question is it just too much of an emotional baggage for a jury to be able to set aside? The juries in most criminal cases are advised you're supposed to set aside emotion, prejudice, all kinds of things, but we're humans. Can we really set aside all that and apply the facts to the law? That's really going to be the challenge for the jury, and we hope that they can just apply it in a way that is fair, and that's what the judge is trying to ensure.
Well, we will start to see how all of this plays out in just a couple of weeks. That trial begins January 23rd. Attorney Sanford Shulman, as always, thanks for coming by.
Thanks for having me.